Now this is the ruling. Republic versus Bharat Ramji, Harish Ramji, and Ashvin Ramji. E635 of 2025 as per the mandate. By councils of Bharat Ramji, Mandi, and two others. Councils hearing, Senior Counsel Harvey, Orenge, Degwa, and Echesa for the three assumable brothers, having brought it to court's attention that there was a stay order issued by the Court of Appeal by Court of Appeal judges Lesit, Mativo, and Gashoka, all Court of Appeal judges. Via civil application number Nairobi E388 of 2024, and it is dated the 20th day of September 2024. Now the key wordings of the three-judge bench in regard of title Land Registrar number 11,895/50 is the same land reference in the purported charge sheet before this court. I will quote the latter part of the ruling being judicial review application number E010 of 2024. And I'll quote it verbatim. Before we conclude, counsels for the interested party argued that the applicants have a similar application pending before the trial court, which is described as abuse of the court process. Indeed, the interested party has annexed a copy of applicant's application seeking similar orders as those sought. In the instant application, this allegation was not denied by the applicants. It is secondary thus. This court exercises original jurisdiction under Rule 5(2)(b) of the Court of Appeal Rules 2022. However, the practice in similar application before the Superior Court and this court at the same time must be abhorred because it creates a fertile ground for courts to issue conflicting decisions. One wonders what would happen if the High Court were to grant the stay and this court declines it, and vice versa. In a respectful view, a party should choose one forum at a time to ventilate its grievances. Be as it may, a determination of the instant application renders the stay application before the Superior Court and C. Mwakele and three others versus Vipingo Development Limited and two others by civil application number E060 of 2021, which is dated the 16th of December 22, and the ruling therein was granted. Now, in conclusion, in their finding, that is the Court of Appeal, the applicants have satisfied both requirements under Rule 5(2) of the Court of Appeal rules. Accordingly, allow the application dated the 31st day of July 2024. We hereby state the third respondent's decision to arrest and prosecute the applicants pending the ruling hearing and the determination of their intended appeal to this court. The cost of this application shall abide the outcome of the intended appeal. End of quote. Now, when a court lacks jurisdiction, the power to hear a case, it means the proceedings are nullity ab initio, and the court must stop. It cannot proceed even if parties agree, because jurisdiction is fundamental, can be raised anytime, even on appeal, and cannot be granted by consent, with the proper action being to withdraw and refile the correct court. In the celebrated case of the owners of motor vehicle William versus Caltex Kenya Limited, Nyaragi JA as it then was held that, and I quote, jurisdiction is everything. Without it, a court has no power to make one more step. Where a court has no jurisdiction, there would be no basis for a continuation of a proceeding pending other evidence. A court of law downs its tools in respect of the matter before it is, the moment it holds the opinion that it is without jurisdiction. In conclusion, considering that the superior courts have pronounced themselves in this matter, key to note that the subject suit is on title LR number 11,895/50, this court downs its tools. For the ODPP, due diligence and disclosure is a legal mandate enshrined in law and in the Constitution. It would be disastrous for this court as a Chief Magistrate's Court to have issued orders in this matter, yet this matter has ruling over the subject matter. This court reiterates that we be each other's keepers even when seeking orders. I fret otherwise. If any one of us would have gone otherwise unknowingly, yet all these are documented and available. As such, this plea cannot stand as it is, and the same is dismissed as defective and cannot stand for the aforementioned reasons.
We're most obliged, Your Honor. Thank you so much.
No. I want to stand and have personal report.
Okay. Thank you, Your Honor. May you have a blessed day.
Any other?
No, Your Honor. Thank you for your reading.
Thank you.
Much obliged.
Any other? Close down this.
Just to thank you, Your Honor. We just have to thank you for handling the matter expeditiously from Friday 11, and you dispensed with it. Thank you.
Any other person you want to say before we close this matter? Okay. It was a personal bond, so the same is discharged. Okay. The ruling is read.